Welcome everyone to our second basic course on Indian patent filing. In this section we'll learn about forms which are required to file a Indian patent application, fees which is involved, and also we'll learn about the steps to be taken before filing a patent. Also we'll see some specification requirements and drawing requirements to file a patent in India. So we'll start with steps to be taken before filing a patent. So whenever you decide to file a patent for yourself or for some researcher, as a IP aspirant or a patent professional, if you decide to file a patent for someone else, then the first and foremost thing you should do is to document the invention in a proper format. I am not talking about the patent drafting, I am talking about the documentation of the invention in a proper format. So this will involve, or this will tell you that what was the prior art, what the inventor has done something new, what is the novel point of the invention, and then the conclusion. If some drawings are also there, you should involve or you should include that drawings also. Once you prepare this document of invention, that also in general terms we call it as invention disclosure. Once you take this invention disclosure from the inventor or you prepare for your own research work, second step is patentability search to estimate chances of getting a patent. So whenever you decide to go ahead for a patent, you should always do a patentability search. Patentability search will tell you that whether your invention has all the patentability criteria. I hope you all remember what are the patentability criteria. We have already learned in the last lecture. Even if you don't know, we'll cover it in the next slide. So once you know that your patent is or your invention is patentable, you know that what are the chances of getting a patent, because filing a patent is a costly affair and also it takes time. So before putting your efforts, before putting your money and time, you should know that what is the cost of your patent, what is the cost of your invention, and if you get the patent, then how much money you will get out of it. So this all involves patentability search. Everything is happen in patentability search, and this should be done by yourself if you are good in patent analysis, if you are aware of all the patent databases, and if you know what type of keywords are useful for what kind of databases, and if you are also aware of the specific databases according to your invention. If you know all these things, then you can do it by yourself also. Otherwise you should take a professional help to do this patentability search. Next is confidentiality of the invention. So even if you have done the patentability search, or during that time of doing that search also, it takes 2 to 3 days or 4 days by a professional to do this search. So even when you are doing this search, you should always maintain the confidentiality of your invention. You should not disclose that invention, because that is still in a process. So until you file a patent, you get the filing date, you should not disclose your invention to anyone. Next is deciding jurisdiction for foreign filing. So in this stage of patentability search, you get to know that how much is your invention patentable and what are the chances of getting a patent, and also you know the commercial value of your patent through this search, because when you see other patent which are already been filed by some other inventors, you get to know that how much this technology is advancing and how much you will get as a output. So once you know this estimation about your patent invention, then you should decide in which all jurisdictions you want to go for a foreign filing. So in the last lecture I told you that patent filing is a territorial right. So if you are filing in India, you will get the right only in India, and people in US or Europe won't be asking or taking your permission to use your invention or to use your to manufacture your invention. So if you think your invention has a potential to sell in US market, then you should decide that your patent should be filed in India followed by filing in US. So this estimation should be done before going ahead for Indian application. Even if you are going for Indian application, you get, after filing an Indian application, you get 12 months time to decide in which foreign country you want to file. But few patents like computer programs and some other electronic related patents, they have a good market in foreign only and not in India. For such cases, if you are just going ahead with Indian patent filing and then going ahead for US, so that will be a waste of money for filing a patent in India. So that is why even if you decide at this stage only whether you want to go ahead for Indian patent filing or not, that will be good. So at this stage only you have to you need to decide that whether in which jurisdictions you want to file, including India or excluding India. Next is criteria for getting a patent. So once you get the patentability search done, or before getting a patentability search done, also as an inventor you should know that patent office give you a patent grant only on inventions and not on discoveries. So discoveries mean you are just discovering a new form of a known substance or new application of a known substance. So suppose I am saying that now instead of using sugar I am using jaggery to sweeten something. So that is I am only discovering the property of jaggery. I am not doing some lab work to add that property in a jaggery, right? So this is called discoveries. So discoveries as such are not allowed in Indian Patent Office. Also, there is a section in Indian Patent Act, section 3 of non-patentable inventions. So before deciding to go ahead for a patent, you should always determine whether your patent is complying with this section 3. So section 3 tells about you all the invention, all the things like mathematical formulae, topologies, then literary work, then discoveries. If something you are claiming which is contrary to the well established laws, then also it is not patentable. So section 3 has few around 10 to 11 points which are non patentable. So you should first see that whether your invention is falling under those subsections of section 3 or not. If it is falling, then there is no use of going ahead. If it is not, then you should go ahead. And even if it is falling under section 3, you should consult a IP professional that what are the ways to go ahead. There are always a way to claim your thing in a different way if your patent is falling under this section. So for that you need to take a professional help. Next is patentability criteria. We have already talked about this in the last lecture of introduction to IPR, that patentability criteria involves novelty, inventive step and industrial application. So once you know that your invention is not falling under section 3, next is you have to determine whether your invention has these three criteria. So first is novelty, second is inventive step and third is industrial application. Novelty means your invention should not have been disclosed in any format in any media. So it can be Google, it can be book, it can be an article, it can be a public use, it can be anything, verbal disclosure also, selling of your product also, anything will kill your novelty. So this you should know that your novelty should not have been killed before filing a patent. Next is inventive step. So whatever you are claiming as an invention should not look obvious to a person who is skilled in your art. So suppose you are from a background of computer science and you are developing a software. So once you develop a software, a person who is also from computer science background, if he sees a software or the application whatever you have developed, after seeing that, if he feels that this is just mere arrangement of few programs and you have not done anything extra, and it looks obvious to that person that your invention is very obvious to him, in that case your invention don't have any inventive step. So your invention should look non-obvious to a person who is skilled in your art. That is inventive step. And then next is industrial application. So whatever you are claiming as an invention should be sellable in the market. If your invention is not sellable in the market, patent office don't give you any patent grant. So you should always see that what is the need of the market, then only you should go ahead for any invention. So next step is preparing documents. So after patentability search, when you decide that your invention is having all the three criteria of patentability and you decide to go ahead for Indian patent application, first is strategize your patent claims. So now after the search, you know that what are the novel points of your invention, because you can do a analysis with the help of your IP attorney, or if you are good in analysis, you can do a patent analysis and you can compare all the prior arts with your invention and determine that what are the novel points in your invention. Novel points plus inventive step you have to determine at the stage of patentability search itself. Once you determine that, you have to strategize your claims. You have to decide what you have to put ahead, what you have to claim in the first claim, and what should be your dependent claims. So there would be there are dependent and independent claims. We will learn more about this in patent drafting session. And right now I can tell you that what you want to claim or whatever your novel points and inventive steps should be given in the first claim itself. So that you have to strategize based on the patentability search. Next is determining novelty and inventive step. So strategizing means determining your novelty and inventive step. There can be 10 novel points in your invention, but you have to decide which point you want to add in a first claim and what other points will be there in the dependent claims. So that you have to determine. Next is preparing required documents. So whatever the documents are required as per your category, in which category you are applying, through whom you are applying. If you are going with the IP attorney, he will tell you what are the steps or what are the forms to be submitted to the patent office. Otherwise, if you are doing by yourself, then also you should know what are the forms, necessary forms to be filed with the patent office. And these documents should be based on where you are filing. So if you are filing in India, there are different documents, and if you decide to go for foreign filing, then you need to take a foreign filing permission from IPO. So without taking a foreign filing permission from Indian Patent Office, you cannot go ahead for any foreign filings. Suppose you have an invention related to computer science and you don't want to file in India because there is very less scope of getting a grant in computer science department as per the patent act, but otherwise it is not, because there is a huge scope also. So suppose you decide to go only in US, you have a good market in US and you decide to go for a US patent application and you don't want to go in India. If you don't want to go in India and directly go to the US, to directly file a foreign application in US, you need to take a prior permission from Indian Patent Office that I am not willing to go ahead in India, but I want to go in US. You have to wait for that for 6 weeks to get a reply from Indian Patent Office. Unless they give you approval to go ahead, you cannot file a foreign application. Otherwise, after filing in India, you can always go ahead for foreign filing. But if you don't want to file in India and directly go for the foreign filing, then you need to take a permission. So next is types of patent application in India. So suppose you decide to go ahead for Indian patent application, then what are the types? First is when to file. First you have to decide when you are willing to file. Based on that, you have to decide what type of application you will be going ahead. So if you are filing at the earliest, if you want to file at the earliest and your invention or your work is not completed means it is completed but you need some more time to do the execution part of it, to see whether that product, whether that manufacturing method is working or not. So to see that, what you can do is to file a provisional application. So what provisional application does, it establishes a priority date or it establishes a early ownership on your name. It preempt others to use your invention after that date. So suppose today I am filing and I need 6 months more, 8 months more to execute my invention, to do some lab work on my developed invention or developed product. Then from this date, and I have filed a provisional application today, So from this date, no other person can file the same invention related to my technology. Not related to exactly same invention, nobody can do, because while executing or while um, performing any lab work on your device, someone may steal your invention, someone may steal your disclosure and file an application on their own name. So that is the fear of every inventor. So in this case, what they can do, they can file the invention. And what patent office tells you, that patent office says if you file a provisional application, then we are giving you 12 months of time to file a complete specification. So in complete specification, you are providing all the details. In provisional specification, you are not providing all the details. Basically, you are not giving the claims. Basically, you are not telling them that what is the claim, what is the novel point of your invention, because you have not worked out that invention. So you need time for that. So you have just given the description of your invention, but you have not given the claims and working examples of your invention. But within 12 months, you have to give those complete details of claims and working examples to the patent office, and that complete details is given as a complete specification. So there are two types, and this is for those who have not done their work, or who need time. But there is another mode, that is called complete specification. So suppose your invention is complete and you are ready to just file. In that case, you can directly go for complete specification, and it will give you the filing date directly. In provisional specification, you only get the filing date, that is priority date. I will tell you more about priority date. So in complete specification, you get the filing date as well as priority date, but in provisional specification, you get the priority date. So what is priority date? Priority date refers to the first filing date. So if you are filing a provisional application, your provisional application date will become your priority date. And after 12 months, you can file a complete specification, but your date will be considered from the date of your provisional application. That will be your priority date. Or to the earliest filing date in a family of patent application. So suppose you are filing 7-8 applications, one in US, one in Europe, one in Japan, in China, in India. So your priority date will be the date for your first filing, for your earliest filing. So suppose first patent you have filed in India today in 2021, and next you are filing in December 2021. So your priority date will be September 2021. So the date of your first filing in the family of patent application. Later on you can file for 7-8 more, but your priority date will be considered as your first filing date. Next is, if the applicant has filed a number of related patent application, the priority date would be the filing date of the earliest. So I already explained you this. Basically it means wherever you disclose your invention first time, on that date will be considered as the priority date. Then we'll move to the next, that is necessary forms required for filing Indian patent application. So first requirement is form 1 with a proof of right. So form 1 with a proof of right, in form 1 itself there is a section for proof of right. I'll show you in the next slide that what form 1 has. Second is form 2 with complete specification. This form has all the basic details or the complete details of your invention. First form 1 only have your other details like name, address, phone number, email of inventors, applicants, patent agents, all those things. And form 2 have the complete details of your invention. Then form 3 is required to file to tell them that there is no other foreign filings done till date. So suppose you are first filing in India, and then going ahead, then you will say that I don't have any foreign filing till now. But suppose a Chinese person comes, he has first filed in China and then came to India, then he has to file form 3 and he has to write that first filing has already been done in China on this date, and now I am applying it India. So this is foreign filing informations in form 3. Form 5 is basically the details of inventors. So this is only filed if you are filing a provisional and then going for the complete specification. So sometimes it happens that while filing a provisional, inventors are different, and then while executing you are not including few inventors. So in that case this form 5 is required only if you are filing as a provisional plus complete. Form 26 is required when you are filing through an attorney. So if you are going ahead with your application with the help of any attorney, then you have to give form 26. Last is drawings. Drawing is a part of form 2 only, but that has to be submitted separately in a separate sheet. So I will tell you more about drawings also. So these are the necessary forms required to file an Indian patent application. Apart from that, this also there are few forms which are required as per the applicant basis, right? So if you are a startup, there is a form for startup. If you are going for early publication, there is a form for that. If you are going for examination, there is a form for that. If you are going for expedited examination, there is a form for that. But necessary forms are these. Without these forms, your patent will not be considered. So these are very required forms. Now first form. So this is the just an image of the first form. The form 1 is very long. I have just taken the part which is explainable and which is required to be explained. So see, you can see that first you have to give the applicant details. If 2 or 3 applicants are there, you have to give all the names and address, nationality, plus inventors. If 2 3 inventors are there, you have to give the name of all of them. Then title of the invention, whatever is the title of your invention, you need to take. Address for correspondence. So suppose if you are going with the IP attorney or patent agent for your invention, you have to give the address here. Of course they will do all these formalities, but if you are going by yourself, then you have to give your address for correspondence. For all the documents will be sent to that particular address. Then priority details, these are for convention countries. So suppose someone is coming from outside and filing in India, then they need to fill this for point number 5, point number 6, point number 7. Point number 7 is basically for divisional application. So there is one more type, that is divisional application. So that is totally different. We will not talk about that. Then point number 8, particulars for filing patent of addition. So like divisional, there is also patent of addition. Then ninth, so this ninth point is very important. So proof of right is basically point number 9. So you need to take the declaration from the inventors that they are the inventors and they are giving this right to the applicant. So in most of the cases, basically in academics, professors and students are the inventors and college is the applicant. So in that case, this declaration becomes very important, or proof of right becomes very important, wherein professors or inventors will give the declaration that this work belongs to me, and with their signature, and they will say that we are giving this right to the applicant mentioned in the application. Without this proof of right, your application will not be considered. So you have to give this declaration. Suppose in form 1, during filing form 1, you fail to give this proof of right because inventors are not available, they are in some different country or state, and you are unable to take the signature from them. So you can separately also send this declaration in some stamp paper legal format, wherein this declaration by the inventors can be sent. So that is called separate proof of right apart from form 1. So when you fail to give this proof of right in form 1, then only that separate declaration by the inventor is required. That should be done on a stamp paper or a legal paper. The next is form 2, that is complete or provisional specification. So this is the most important form of filing a patent application, because this is where you need professionalism, or you need professional drafting skills to draft your application. So form 2 is nothing but the draft of your patent, draft of your invention. So see, you can see that title of the invention, applicant details, then preamble. So here preamble means you have to decide whether you are going for provisional or complete. So in preamble section you write whether you are going for provisional or complete. Then in description you have to give all the basic, like detailed description of your invention. Then claims, you have to write the claims. As I told you, you need to strategize your claims, you need to decide what you are claiming. Based on your claims only your description should be there, like your claims and description should match. You cannot just write something in claim and then you are not describing that in your description, so that becomes inconsistent. So you should keep in mind that whatever you are claiming, there should be a complete description of that in description part. Then once you complete the claim, there should be date and signature. That date and signature will be of the person with whom you are going. So if you are the applicant and you are not taking the help of IP Professional, then there will be a signature and name of the person, of the applicant. And suppose you are taking the help of the patent attorney, then they will sign and they will write their name. Last is abstract. So abstract is also like very specific in terms of patent specification. So what you are writing in abstract will be published first. So when your when your patent is published first time, like after a month or maybe after 18 months, so once it is published, only applicant inventor details will be there and only abstract will be published, no other details will be published. So what you are publishing is very important, and what people are seeing in your invention and at the first sight, that is also very important. So abstract in terms of patent application is very important, and that has to be in line with the claims. So next is formal requirements of patent specification. So we will be talking more about form 2 in this slide. So basically form 2 is a techno-legal document. I'm talking about the patent specification which we are giving on in form 2. So form 2 is a techno-legal document. Techno-legal means you have to keep in mind all the legal aspects of patent act, plus you have to give the technical details of your research work. So once you are pro in both of this, then only you should decide to go ahead for the patent drafting. It describes and specifically claims the invention. So as I told you, once you strategize your claims, you have to describe it and specifically write what you are claiming as your invention in this document. Then form 2 is it particularly describes and ascertains the nature of the invention and the manner in which it is to be performed. So one section we have seen in the last slide, in form 2 there is a description. So description basically should tell or should describe everything about the performance or the working model of your invention. So what are the steps to be taken to develop that model? If you are going for a model or a device, then each step, how you have taken, what steps you have taken to develop that product, that has to be written very clearly. And then the nature of your invention, what is the nature of your invention, that has to be written in the form 2. You have to understand that patent office rewards disclosure rather than secrecy. So if you have a feeling that I should not disclose this and I should disclose that to the patent office will not give you the grant, because patent office appreciates if you are disclosing the complete thing in the patent disclosure. But as a patent attorney, I will say that there are few things which should not be disclosed to avoid infringement of your patent. Because if you are disclosing everything, people suppose out of many countries like 134 or 135 countries, if you are taking protection only in India and US or Europe, other countries or people in other countries are free to use your invention. So if you are disclosing everything in your invention, like minor details also, or few things which can be strategized to write in a way, so basically patent writing is a skill where you are disclosing everything but still hiding few things, but very professionally. For that you need skills to understand that what has to be disclosed and what has to be hidden, because if you are keeping it secret, then patent office will definitely ask you to give that details in the subsequent examination which happens after filing the application. But that has to be skillfully done, wherein you are fulfilling the criteria or requirement of the patent office, and also you are maintaining the secrecy. So this is just a patent professional I am telling you, but otherwise patent office says that you need to disclose your invention completely with all the details. If you don't disclose, if you maintain some secrecy, they will ask you to file those things in the later examination process. Next is, this right is given with some limitations, that is, it excludes other from making, using and selling your invention, and it is called a exclusive right. Next, it provides others with ability to use that information to invent further, thus pushing the technology forward for the benefit of the society. So this is one of the like relaxations given by the patent office, that if someone wants to use your invention only for only for the purpose of doing further research, or to teach someone, or only for the educational purpose, then under Bowler exemption, that is called Bowler exemption, under Bowler exemption, those these two things are allowed. So without paying you any money, so they can use your invention without your permission and without paying you anything, only for the purpose of doing further research, also for the purpose of education. So these two things are there in Bowler exemption, because this pushes the technology forward for the benefit of the society. Then I told you that drawings are part of form 2, but that has to be submitted in a separate sheet. So submitted on a separate sheet, drawing should be submitted, and that has to be made on a scale sufficiently large to show the invention clearly. Suppose your invention is very much like the device which you are showing is complicated with all the parts, the lining and all the things, it should be black in color. You should not use any color things on your drawing sheet, and that has to be made very clear, so that examiner who is seeing, he should easily understand that what you are actually claiming out of this drawing. So if you are claiming a part of some device, then you are showing the whole part in the drawing, but your part, what you are claiming, should be clearly visible in that drawing. That is what the requirement of patent office. Sorry. And then publication number, date of publication, patent number if it is granted, and date of grant. All these details you have to give if you are a foreign applicant, or if you have filed a patent application first in foreign country and then in India. So basically this is not allowed in India, first to file in foreign and then to India. Only if you are not filing in India, going for foreign application, that is only allowed. So this is basically for this table is only for those who are filing from foreign, like for foreigners. So next is form 26. So this form is required if you are filing your patent with the help of any patent attorney. So in this form you are giving an authority, power of authority to that person, to that patent attorney, and writing that this, I am authorizing this person as a patent agent or an advocate to file your patent on behalf of you, and all the further communication should be sent to him or her directly at the address, whatever address he mentions, and this has to be signed by you as well as your attorney once you decide to go with the attorney. Then next is government fees at various stages. So these are the required fees to file a patent. So we only spoke about filing a patent application. So if you are filing as a natural person doesn't mean that only one person is like eligible. So suppose 10 people or 5 people, 5 as an applicant, and they declare themselves as a natural person, that is individual person. So 5 individual person are filing for a patent, then the fees would be 1600 only. Even if you have a startup certificate or a small entity certificate, and also educational institutes. So now after September 25th, educational institutes are also included in this category only. So if you are filing in any of this category, the fees would be 1600 rupees. Apart from this, there will be other fees like filing a request to publish. So your patent gets published by default after 18 months if you don't pay anything. But if you want your patent to get published early, then you need to pay an early publication fees of 2500 rupees. Then this is a compulsory fees, that is the third fees, request to file an examination. So once you file your patent, you have to request to the patent office that please examine my patent application. So for this request you need to pay 4000 rupees, but this is for the normal examination. This may take time. It can take 1 year, 2 year, 3 years or 4 years. So that depends on your invention, like field of invention and many things. So if you wish to go ahead expeditedly, then there is an option of filing expedited examination as well, that is 8000 rupees. So and the same thing is for the others, like the fee structure for all of these things for others. So others means who are not falling under this category, then they are others. And even if a startup with someone else, like a large entity or some industry, if they are filing, then they will fall under this second category. Clear? So basically this totals up to 5200 rupees or 8400 rupees, 8200 rupees, something like that. So the government fees involved is 8000 plus 12000, sorry. So if you are going with the expedited examination process plus early publication, then the total comes to be 12100 rupees, something like that. And if you are going with the normal examination, then it comes to 8100 rupees. So now we'll introduce you to the e-filing module. So first you have to search on Google ipindiaonline.gov.in. Once you go into that, there will be comprehensive e-filing portal. So you have to click on patents, and then there will be a comprehensive e-filing portal. When you go in that, they will be asking where you want to file, what you want to file. So there will be patent, designs, trademarks, different sections. So if you are going for patent, you have to click to patent. So that will here it will come as e-patent filing. Then this login page will come. Here you have to, if you are doing for the first time, you have to create your login credentials. One thing you need to note here, that patent filing requires a digital signature. Without digital signature, you cannot file as an inventor and also as an attorney. So whether you are looking to file for someone else or whether you are filing for yourself, you need a digital signature. So and also then digital signature has to be installed here on this platform. So that all those things are like technical, you need to do it on your computer or laptop and beforehand, so before filing a patent. Once it is installed, you have to log in here. So there are two options, there is a option of password as well. So you need to create your password as well as you have to install your digital signature, both has to be done. It is not an option, like if you think that without digital signature you can work with only work with password, that is not allowed, because later on after filing, after submission, they will ask you to digitally sign your documents. So there you have to install the digital signature. So once you create this password and username and install your digital signature, you log in. After logging, there will be an option of new application. Here in new application you go fill the details, and there will be an option of upload. Here in upload you have to upload all the required forms which I have told you, and other forms which will be required as per your category. So here you have to upload all the documents, and then you have to, once you upload all the documents, you have to go to the sign document. So signed documents means you are digitally signing the document. So once you go to the signed document, it will open your digital signature and it will sign. If it is digitally signed, then next is proceed to payment. So with proceed to payment, you can just go to the payment portal and pay the fees. After you pay the fees, you will receive one CBR, that is a receipt for filing a patent with patent office. In that receipt, your name, if you are applying directly without a patent attorney, your name will be there with your address, your title of invention, date and timing of filing, and how much fees you have paid, those details will be there in that receipt. After you get that receipt, you will also receive a mail from patent office that which will have application filing report. In application filing report, applicant's details will be there, who are applicant for this patent application, title and date of filing. So suppose if you are going with the patent attorney, so in receipt the name of the patent attorney will appear, but in application filing report applicant details will be there. So with this I will end my session on Indian patent filing. Thank you very much for listening, and I hope I have cleared all the formal requirements to file a patent in India, also some specification details, and keep learning and follow us on social media. We'll be posting about other courses as well on LinkedIn and other social media. Follow us on Instagram and FB because we will be taking revision of these courses on that, and there will be some short MCQs as well, and you can post your questions as comments on those social media. So follow us on Instagram and LinkedIn and also on FB. Thank you.